Good morning. Are you Leroy Harris Jr.? And this is cause number 24 DCCR 0404. Mr. Harris is charged with the first degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in two cases on that same date. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years, up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the murder case with a dismiss in the pending felony. What pending felony is there? Well, that's the MTRP.
MTRP.
So really wouldn't be a dismissal of it. It's just the MTRP on a state jail felony. Well, so I'm going to mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30.
30,
Yes.
not 40.
Correct.
So is it okay? So Mr. Harris,
I don't think it makes a difference, but just the paperwork.
So the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket, and Mr. Burbank will begin preparation for trial.
Thank you, Anna.
Thank you. Yes.
And Judge, just may I, for the record?
Yeah, hold on just a second.
Why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank, but it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you.
Thank you.
All right, you can go back with the bailiff. All right, sir, you're Asa Jones, and this is cause number 25 DCCR 0963. Mr. Jones is charged with a first degree felony offense of aggravated assault, and the case is set for trial to begin with jury selection next Monday. And what is the announcement?
You should be ready to go.
State's ready.
All right, it is likely going to be at the top of the list. I have one other that's potential, but it sounds like there might be some issues. So, but you'll know today after docket. I do want to make sure you understand, Mr. Jones, that after today, I will not accept any plea agreements. It looks like I've got a plea bargain rejection from January of this year where you rejected a 25-year term. Has there been any change in negotiations?
No, Judge. Your Honor, we have a witness that would ask the court call the name of, please.
Okay,
Atlanta Gallo.
Atlanta Gallo, please.
We asked that the court admonish her, she's under subpoena, admonish her about the consequences of not showing up for the trial next week.
If you'll just have her come over here on this side. Good morning, ma'am. And your name's Atlanta Gallo?
Yes, ma'am.
And Ms. Gallo, we're here in clause number 25 DCCR 0963, and Mr. Jones' case is set for trial for next week to begin on Monday. You are placed under subpoena for that, and I just want to make sure you understand that it is required by law that you show up whether you want to or not for court next week. At whatever time the district attorney tells you and whatever time that subpoena told you, you have to be here. If you don't come, now that you've been given this order and that subpoena, there could be some consequences where you would get in trouble. Do you understand? You could be held in contempt of court. There would be a fine. You could potentially go to jail yourself for not showing up. Do you understand? Okay, all right, you're free to step back out.
Thank you, Judge.
Excuse Judge.
All right, anything else then? So, Mr. Jones, I do want to make sure you understand that after today, I will not accept any plea agreements. And again, it's very likely that your case will be at the top of the list. Mr. Burbank will know that after docket today. Do you understand?
Yes, ma'am.
Okay, I'll let you know after docket then.
I have to excuse Your Honor.
Yes, sir. Good morning. Are you Logan Eaglin?
Yes, ma'am.
And this is cause number 26 DCCR 121123, excuse me. Mr. Eaglin is charged with murders. Case is set for trial to begin with jury selection next Monday. What is the announcement?
Your Honor, so there is some additional discovery that was just provided to me, and I have not had a chance to review that with my client. So I would like just one more brief reset so I can visit with him and go over all of that discovery.
So I guess my question is, if it's just going over discovery with him and making him aware of all of that, then I feel like that's something that could take place soon, today, go over everything. If there's any change, y'all could let me know, unless there's some other investigation or information that you're still waiting on or you need to find out.
No,
Okay, well, do you want to?
There is, I mean, it was, an additional witness has come forward, that, this defendant has made a admission to, about committing the crime. But it is another inmate, so we would, I don't know. I think if they want time to investigate that, maybe even having try to interview him. State would not be opposed to that, we're not opposed to resetting it one time for trial.
Is that your intention?
Yes, Your Honor.
Okay, so I'm going to, and it was also, it looks like it's been reindicted. This is the third reindicted.
Yes, Judge.
So, which, I mean, the information that you have is all the same other than the new information that you just got yesterday, is that
Yes, and
correct?
then I also got some new media yesterday in this case.
So here's what I'm going to do. I'm going to reset the case 45 days on an announcement docket. That way, if there's any change in, well, actually, I'm just going to reset it on announcement 30 days. If you need an investigator, you can get that, make that request
Yes,
quickly.
ma'am.
We'll get you the funding for it. That way, if they need to go visit with any additional witness, let's try to get it all done within 30 days. If something changes and there's some deal that we reach on the 30th day, great, then we'll take care of it. If not, it'll go right back on the trial docket at that point instead of us waiting 3 months for another trial docket.
Yes, ma'am.
Okay, all right, you can go back
Thank
with
you.
the bailiff. And Mr. McCray is charged in cause number 26 DCCR 0399 with the first degree felony offensive murder. And in cause number 21 38959, we've got a motion to revoke probation for an aggravated assault causing serious bodily injury. And what is the announcement?
Your Honor, essentially, it's the same announcement that I just made previously on the last case. There were some items that were missing from discovery that I requested. They were just recently responded to and provided. I'm not sure if everything that I asked for was provided, but I need to review all of that and go over that information and evidence with my client, just
Okay.
to ensure that we have everything.
Sure, so we'll do one more reset. Is there anything else that you know of that you're waiting on that she does not
No,
have?
Judge, these were things that she had asked for that weren't in the file that we went and got.
Good,
and brought
okay.
into the file.
So, Mr. McCray, I'm just gonna reset your case, a normal reset for about 30 days. That'll give Ms. Prazo some time to come go over all of the new information that she's received. At that next court date, we'll need an announcement whether or not you're gonna go to trial or if there's some deal that's reached, okay?
All right.
All right, thank you. Good morning, are you Jaden Brantley?
Yes, ma'am.
And this is cause number 26 DCCR 0422. Mr. Brantley, you're charged in that case with the first degree felony offense of aggravated robbery from February 6th of 2026. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And if I follow the agreement, I cannot give you more than 25. I could give you 25, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have a jury decide if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to a jury trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
You want to set up a trial?
Do you want to visit with Mr. Rojas again?
You talk some more?
Okay, I'll hold it. And if you need some time to go out and visit, just let me know. I can give you a week or two, but I'll hold it for a little bit.
Yes, ma'am.
All right, go back with the bailiff. Good morning. Are you Manuel Cardenas Jr.? And Mr. Cardenas was previously in court, entered a plea of guilty in cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Senior, your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.